Chapter 14, Paralegals and Ethics. Ethics are an important role in how law firms operate. The practice of law is essentially a public service. It provides services to the public which are valuable to everyone, not just the individual client. Consequently, lawyers and all members of law firms have to comply to a certain set of rules that are deemed fair by the American Bar Association and the state bar associations. All states except California follow the American Bar Association's model rules for professional conduct. These rules cover many things. However, for purposes of this class, the unauthorized practice of law, giving legal advice, confidentiality, and the setting of fees are the most important ones to know. The unauthorized practice of law is practicing law without a license. The definition of practice is used very loosely. Thus, someone who practices law and is not authorized to do so, which is anyone who is not a licensed attorney in that state, can be convicted of a third-degree felony in the state of Florida. So it's very important to know what constitutes practice and what does not. Unauthorized practice of law includes, but is not limited to, appearing on behalf of others in court, drafting documents that create legal rights without attorney supervision, giving legal advice, holding oneself out as a lawyer, or soliciting new clients. Paralegals can avoid the unauthorized practice of law by always working under attorney's supervision. Also, avoid giving legal advice. Giving of legal advice is the easiest way of getting in trouble and can include very simple things. For example, assisting a client in filling out a form, and the form asks a question about some sort of legal right, or how do you wish to proceed, or something along those lines. Advising someone as to how to fill out that form constitutes legal advice because it is filed with a government agency and also affects their legal rights. Therefore, it is giving legal advice. Should only draft documents on behalf of the supervising attorney, and don't retain clients or set fees with existing clients or new clients. Another important thing is that paralegals should always identify themselves as a non-lawyer. So it should be done at the initial client contact, all in-person meetings, and should also be included in email signatures, business cards, and all of those types of identifying bodies. Legal advice includes listening to a client's story, applying knowledge of the law to that story, and giving your client an opinion on what they should do. It's a very loose terminology, and if there's any question about it, or if you're unsure about whether you're giving legal advice, you are probably giving legal advice and should not do so. If you think that the client is asking you for legal advice, you should at that point immediately tell them that you are not allowed to do so and that they would need to consult with the supervising attorney. Lawyers and the staff owe clients a duty of confidentiality. Confidentiality refers to all of the information about the client's case, not just what they tell you. So things that you read or things that you hear about the client or papers you've reviewed are confidential. There's a difference between confidentiality and information which is privileged. Privileged information is simply a rule that is created for testifying in court. The rule of confidentiality applies regardless of whether you're in court, and you cannot reveal any information at all about a client to anyone outside of the firm or the lawyer without the client's permission. This includes the name of the client or anything that could be used to identify them. So to preserve confidentiality, don't talk about clients or their cases, don't forward any emails, don't allow anyone to use your work computer, keep files safeguarded, and get clients' permission specifically to discuss the case with others.